Mr. Stonewall, you have the floor. I just want to clarify, did you make the motion or did somebody else on that side of the room make the motion?
I did.
Thank you. Mr. Hadley.
Thank you. And this question, since I'm not on the Judiciary Committee, I appreciate input from you folks, but I also appreciate it from Mr. Stone in my next and final question. The central tension or the dilemma that I deal with here is that we want to strike a balance, if we can, between really acting aggressively against egregious, willful violators, and given the anecdote that was given in the initial testimony, about egregious violations being capped at $75,000, given the way that you could find 3 instances of wrongdoing, that's clearly not what we want to be doing. We also don't want to be driving companies out of business for mistakes that may have been made inadvertently, even if they were mistakes and violations. And what this does, this bill provides dramatically increased flexibility to Dogger, and has the ability to use that hammer, but also if Dogger chooses to overreach or mistakenly overreaches, the operator is left with very little recourse, if I understand it. If this becomes a judge's order, a court order, essentially, when I know I'm oversimplifying, but when Dogger reaches a final determination, that is a very tough. We're counting on very good performance on the part of the regulatory agencies. So I don't have a solution here, but I'm trying to understand if giving by turning shall to may and making this completely broad, open-ended flexibility to Dogger, no matter how egregious or how incidental the violations may be, are we asking people to invest in this business in California with very limited confidence about what could happen if they commit an incidental violation?
One comment about the shall to may. Frankly, the may in that situation gives us the ability, for example, if it's a very, very small, we almost think of it the opposite in many cases. If it's a very, very small operator, that can then go into consideration what's an appropriate level fine for a much, much smaller operator. So I think, as Mr. Stone said, that you want to give the supervisor flexibility to do an appropriate fine, not have our hands tied so it's kind of a one-size-fit-all, a fine. Up to now, our limitation, we're quite very, very limited in our ability to, what level of fine we can actually impose, and we're really looking for the ability to impose an appropriate level of a fine.
No,
let me give you a response based on my previous dealings with the witnesses. Generally, the interpretation of shall is a stronger interpretation that essentially the regulatory agency must do something. May, generally by enviros like myself, is considered weaker. The last time we put a shall in a bill, WISPA responded by fighting that for 4 years because it required action that did not factor in discretion. So frankly, in my experience, if the bill was written with a shall, then they would be telling you that the shall gave them no discretion and is too tough on the industry.
Well, I'm not here speaking for them. I'm speaking for me. And I totally understand the point that may allows you to consider it or not to consider it. That's what may means. But if you may consider the economic impact or the environmental impact of a violation, the fact that it was a very small impact is something you are free to ignore in your assessment of the appropriate penalty or the appropriate sanction. So it is. I can't speak to the prior circumstances that the chairman is referring to, but May here we're giving increased power, increased enforcement authority, increased penalty authority, and we're allowing them to pick from whichever aspects they choose to pick from to ascertain whether the crime or the infraction is serious or not serious.
If I could, Mr. Chair, I think that the department and my joint author have expressed that this bill intends to give some discretion to work with entities that are good partners and good actors, and to have the ability to assign a more severe consequence when it is appropriate to do so. This is the first time I've ever heard anybody say we don't want to have discretion in how a consequence might be attributed to us. But that is the intent of this bill, to give some discretion where it's appropriate and a severe consequence to make sure that those actors are being expeditious in resolving the incident.
Thank you. Ms. Garcia.
In the same area, but in the opposite direction, actually. I agree that the May and what we have here gives discretion, and it goes both ways to give some leniency or move further with more stringent fines. And I do think we need to do something on the fines. They're not fines that incentivize individuals to always do the right thing. So in that sense, I think it's fair. And I think you have an extensive list here on page 4 of what would be considered helping to create a more holistic picture that I think would help on also ascertaining if this is a repeat offender or so forth, so that if they're not, you can work with a good actor and try to remedy the problem. So, but on this list, I have one question about the first one about potential harm. All the other ones, I could kind of wrap my head around how you might get to that. But what does potential harm mean? Do we have code already that defines that, or?
Well, I'll give you an example. If you were to do this out in the middle of a part of Kern County that was not anywhere within miles of anything, and you did some kind of violation that was, say, an intentional violation, it would be different if you did that in the center of an urban area of the same, maybe the community didn't blow up, but it could have blown up. And if such an action, some kind of action was done in an area that was highly urban, we would probably take a different look at it. It was done, way out in a remote area, and the risk was very low. Nothing might have happened, but the risk was much, much greater. The potential harm was much, much greater. And so we would think that would warrant a higher fine.
If I can answer that, Mr. Chair.
Please.
So if there's for example, if there's a gas leak in a community, and it could have blown somebody up or could have got somebody sick, it's great if it didn't. But that just because the operator got lucky and he didn't blow somebody up doesn't mean it should be looked at as a very serious crime. And then I think it's useful to point out that potential harm is used in numerous locations throughout statute. For example, in the labor code, when OSHA goes into a facility and they look at a potential or like a situation where there's dangerous machinery, just because somebody didn't get their arm ripped off doesn't mean it's an egregious violation of those workers' safety. It's also used in the health and safety code. For example, the medical board reviews inappropriate prescriptions. Like, just because you didn't overdose somebody, you could have overdosed somebody. So they look at the potential harm. It's used by DTSC in several places. So it's throughout the codes. And then if you looked at threat or harm or damage or potential damage, it's used throughout the codes. So it's just a way of saying this could, just because someone didn't get killed, you need to look at it as a very grievous violation.
And I think that falls within the idea that we're trying to give some discretion to Dogger here. I have concerns about potential harm, not enough to remove my support of the bill. I will vote for it today, but I do have concerns about that and the potential abuse of that. My second question in the letter of opposition, and I don't know if they're still here. I don't know if they can answer my question. I haven't had time. You said something about confidentiality being an issue, that there's confidential wells about the theft, the techniques used, and that information becomes public. The Department of Conservation is liable. can you explain that to me? And then do you agree that there's a potential for that? And do we have a correction in the bill for that? So we'll start with the opposition and then.
Sure. Brian White here on behalf of WISP again. Yeah, our concern is the provision that would give Dogger the ability to have subpoena power for basically getting evidence for a potential violation. We're concerned that if that does happen, would the operator or the potential violator have the ability to have his documents or her documents basically shielded under attorney-client privilege? If you have subpoena power, that's a pretty substantial legal authority, and providing that to the Dogger supervisor. Not saying that Dr. Bunn would be in this situation, but we don't know who that future supervisor might be. Maybe they're a more gung-ho supervisor than somebody else, and we're concerned that for future administrations, this may not be the right authority to have.
Can you, one of you?
The subpoena power came out of a situation where it was difficult and bureaucratic administratively to have to go to court and get a new court case number every time you wanted to get somebody as a part of an administrative hearing process. So what the subpoena power is in this bill, it makes a Dogger attorney the same as any attorney involved in any kind of civil litigation. They have subpoena power over folks with knowledge of the case. So it just like any attorney, public, private, if they're involved in litigation, they can subpoena someone with knowledge of a case if they're in civil litigation. So with respect to and that's just a clarification because we had some specific issues with courts when we were and had to go through multiple steps with those courts to get those subpoena powers because it wasn't clear. Then second, with regard to the trade secret information or confidential information, if an operator in the process of a civil or of an appeal identifies something that's confidential, we believe that it's implied that we'd be held liable for release of that information, just like any other state agency in possession of confidentiality. And we provide operators with confidential trade secret protection for SB4, for fracking trade secrets. There's confidential wells when operators have concerns about competitors learning about those things. Dogger can handle that confidential information and has. So if the opposition feels like that needs to be clarified, I mean, we feel like we are liable if we release to the public confidential information that's labeled as such by the operator providing it to us.
Right. So you have mechanisms then to protect it.
Yes.
Thank you.
Any other comments from committee members? Mr. Thurman, Mr. Williams?
A few years ago, Dogger was a toothless agency largely captured by the industry. If that change that the administration is undergoing in order to make Dogger an entity that can actually enforce the laws that we make, we have to give them the powers to do so. The oil and gas industry is one of the most powerful industries on the planet. People, we fight wars for these people, okay? Do you think that a state agency can effectively regulate an industry of that depth and power without the same enforcement powers that the Water Board or the Air Resources Board has? And that is just what the intent of this bill is to give them the same enforcement powers that these other agencies have.
I want to thank the committee and thank my joint author who's made a great close. I know much has been made today about making fines applicable on a daily basis. I would simply add this and say, what is the cost to not doing so to public health when there is a significant incident? And that clearly the fine becomes an incentive for all to do the right thing and to resolve them in an expeditious manner that protects the public safety. And we respectfully ask for your aye vote.
Thank you. We have a motion by Mr. Stone, a second by Mr. McCarty. We'll call the roll.
The motion is do pass as amended and re-refer to Judiciary Committee. Williams?
Aye.
Williams, aye. Jones?
No.
Jones, no. Garcia?
Aye.
Garcia, aye. Gomez?
Aye.
Gomez, aye. Hadley?
Aye.
Hadley, aye. Harper?
No.
Harper, no. McCarty?
Aye.
McCarty, aye. Stone?
Aye.
Stone, aye. Wood? Wood, aye.
7-2, carry your bills out.
Thank you,
Thank you.
Mr. Vice Chair. The next bill is AB 2729. This bill creates disincentives for operators to maintain large numbers of idle wells. There are currently 21,000 idle wells within the state of California. That's 21,000 wells that have been suspended operation but have not been closed, which is what you need to do if you are going to make that well safe under multiple circumstances. Many of these wells have been idle for decades. There are 1,322 idle wells in my district alone. This bill includes 5 main provisions. It redefines the legal term idle wells as those who have not been in use for 6 months, and long term as those who have not been used for 5 years or more. It increases idle well fees to incentivize, to create incentives for companies to plug the idle wells and close the well, and the fees could be used by Dogger to address orphaned wells. It eliminates larger blanket super bonds that currently exempt the holder from idle well fees, meaning the largest entities that have the largest amount of idle wells just get one a blanket super bond and pay almost nothing to keep these wells idle. It increases the initial bond fee and requires the bond to remain in place from the initial drilling until it is capped, unlike the current bond structure that only covers constructions. Allows for companies to craft aggressive idle well remediation plans in order to avoid paying these fees. Look, idle wells pose a significant risk to health. And when it is cheaper simply to pay the fees of an idle well instead of closing a well, then the current system basically incentivizes companies to do the wrong thing, which is to leave wells that they are not planning on extracting more oil from idle instead of taking the steps to close that well properly and therefore eliminate the threat that it poses to human health and to private property. Existing laws are insufficient to incentivize landowners to cap those wells, and this measure will make a sizable difference in addressing the large number of idle wells in the state. We have 2 witnesses, as in the last bill.
Chairman, members, David Bunn, Director of the Department of Conservation. Again, as I mentioned, as part of our renewal effort, this is the other bill we're sponsoring this year. And the idle well bill issue has been around a long time. It's been discussed over the last several years. Basically, the state's had about it's hovered around 20,000 idle wells throughout the last 15, 16, 17 years. And that about 4,700 of those have been idle for over 25 years. Our concern is about half of these wells, in fact, are actually penetrate groundwater aquifers. And what an idle well has 2 problems that we're concerned about. One is that they are potentially a conduit to pollute drinking water and irrigation water underground. And 2, if there's not an incentive to plug them, that eventually an operator will just avoid plugging them as long as they can. And at the point they go out of business, the state's going to end up with the liability to plug them. Just to give you an example of the cost of that, we're right now doing a contract in Los Angeles to plug those. At that point, they become what we call orphan wells. So the more idle wells, that like 20,000 wells, our odds that we're going to have more orphan wells. And we're about to plug 2 in Los Angeles. We're going to have to bring a drilling rig into a poor neighborhood, take down the power lines, and it's going to cost about $1 million for the state. And it's oil money, but at that point, it's already caused harm to the community. It's been in the community for a while. The reason we're plugging it is because gas is starting to leak up these wells, and the neighborhood noticed it. That's not really where you want to end up solving it. You want to solve it way before then. You don't want the state to inherit the wells, and then we kind of address it because someone finally calls us and says we smell gas in the neighborhood. So it's a significant problem. Now, I would say this, in the last week, a couple weeks, we've had really good conversations with the oil industry, and I think there's a lot of room for us to work on this bill to solve the problems and to reduce the burden on them. We fully understand that these are expensive activities to plug wells, and I think what the industry will say is that, and some people refer to basically a well that's not going to be useful anymore as essentially a liability. But if it's a well that actually potentially has any chance in the future of being productive again, it's an asset. I think really what we want to get at is those wells that we frankly, really has no more useful value, and that once that gets to that point, that they are in fact plugged. So the purpose of this bill is to incentivize that and to get that number of wells, 20,000 wells, which we don't have the ability to supervise that they're being monitored, down to a reasonable number in the state of California. And this is a really critical, again, essentially you can think of these wells, they're basically straws in the ground. And if we don't test them very often or don't monitor them adequately, it basically means it's potentially a conduit for gas and oil to end up in an aquifer. So that's why we have brought this forward as one of the key reforms in the oil and gas regulation.
Bill Alio for the Environmental Working Group. We submitted a letter, I think, with 14 other groups supporting the bill. I think the author, the department, and the analysis cover the need for the bill. Just say in closing that we appreciate the Jerry Brown administration, the department, and Dogger's ability to, again, look inward and help get a better Dogger in the long run. Thank you.
Other witnesses in support, if you can share your name and affiliation, please.
Mr. Chair and members, Monica Miller on behalf of the County of Santa Barbara Board of Supervisors in support. Thank you.
Corey Bolus on behalf of Environmental Defense Fund in support.
Diana Vasquez, Sierra Club, California, and also on behalf of CLCB.
Keith Nakatani, Clean Water Action in support.
Thank you. Any other witnesses in support? Witnesses in opposition?
Back again. We got to stop meeting like that.
Whenever you're ready.
Good afternoon, Mr. Chairman and members. P. Anthony Thomas, representing the California Independent Petroleum Association, in opposition to the bill. First of all, members, there are three wells. There is an idle well. There is an orphan well. There is an abandoned well. An idle well essentially means that, just like if your car is in neutral, it will be used again. Idle wells, in fact, are not used for either moving on to another project or they've moved into another area. But that well is not environmentally dangerous, and in fact, we intend on using it again for production reasons. An orphan well is just that. It is an orphan well. I believe that the proponents of the bill are referring to orphan wells, not without a parent, if you may, an owner. An abandoned well is one that has been plugged. It has been sealed. It does not possess an environmental hazard at all. The bill is designed to reduce risk to the environment, groundwater, which SIPA supports. However, in the bill's current form, it saddles the industry with unnecessary costs and actually increases, members, the amount of orphan wells in the state. SIPA supports testing of idle wells that should include a risk-based analysis. So should these wells be tested? By all means. Should they be integrity tested? By all means. Full and comprehensive study should come from this. Testing should determine whether a well poses a risk, and it should not be arbitrarily determined by the age of the well. 2729 subjects older wells to being abandoned. However, all older wells are not necessarily bad, nor are all new wells necessarily good ones. More testing of the wells, as I mentioned before, gets older wells to check the quality of the casing for corrosion and is more acceptable from the environmental standpoint. An arbitrary abandonment of wells pursuant to the bill's current mandate is a non-starter for producers. Wells are as much of an asset to a producer as ag equipment is to a farmer, or you may say a car dealer's fleet. We plug 2,000 to 3,000 wells per year, members. We plug 2,000 to 3,000 wells per year for a variety of reasons, including new projects, as I mentioned, reactivation, as well as others. Industry covers 100% of Dogger's funding. 100%. It does not come out of the general fund. There is no need for another expensive, another expensive mandate, especially when oil prices are what they are today. We think that more wells will be orphaned if this bill is passed. And had this bill been in effect in the 1980s, production would be a fraction of what it is today, because the assets of those idle wells would not have been available to our members. The last time that we had a downturn, members, our counterparts, some of the larger ones, left the state, and it left wells here. It was our members who went and bought these wells and waited until the market came back. So what you're essentially doing is attempting to reverse that and remove this. It also, well, let me stop there, members. We believe that the bill has a great deal of holes in it. We think it's more punitive than helpful. If this is something that the authors would like to pursue, we would suggest, humbly, of course, that it remains in committee, and we'd be glad to have some conversations on it. However, in its present form, I'd have to urge a no vote.
Mr. Chair, members, Brian White here on behalf of the Western States Petroleum Association. We're also opposed to the bill. We actually believe this bill will actually create significant unintended consequences for operators, and actually would, as my colleague stated, result in more orphan wells, which is ironic. I don't think this is what the authors intend to do. We have to keep in mind idle wells have been in California for a long period of time, over more than 30 years in California. Oil producers maintain these wells for a variety of reasons. A lot of them are driven by economics. Some are driven by other issues. But we think that WSPA understands. We understand what the author's trying to do. We understand what Dogger's trying to do with this. But we have significant concerns that the bill would have the premature abandonment of wells that could become economically viable at some point in the future. The current language in the bill would create a perverse incentive of actually encouraging well operators to basically orphan their wells, abandon them. No one takes care of them, because the increased fees that are in the bill, no one's going to want to pay that fee. They'll just say, forget it, I'm going to shut my well down, and it will become orphaned. There's also a requirement in the bill that 25% of an operator's well infrastructure actually be abandoned. That's another perverse incentive to just say, forget it, and close up shop. So what exactly is this bill attempting to do? We're still trying to figure it out. If the intent of the bill is to address the abandonment of wells and groundwater protection, we get that. We also think, as my colleagues stated, that requiring the adequate testing really should be the solution for this bill. We think rather than penalizing operators for having certain idle wells that don't fit this arbitrary definition of idle, long-term, or observation, we should be focusing on improving the testing requirements that are in existing law. There's a lot of different types of tests that are out there. We think there's a ripe opportunity to address that. But right now, we think the bill as currently written is very punitive. We had a fairly good discussion on Friday with Dogger and the Department of Conservation, which we think would be headed in more direction of actually improving the testing. But until these provisions about the increased fees, mandatory abandonment of operators' wells is taken out of the bill, we cannot remove our opposition. So for those reasons, we are opposed.
Thank you. Any other witnesses in opposition? If you can state your name and affiliation, please.
Amy Magro on behalf of the California Chamber of Commerce in opposition.
Thank you.
Peter Blocker with the California Taxpayer Association. We're also in opposition. I'd just like to point out that we also have concerns about the fee imposed in the bill, about the legality of the fee under Proposition 26, since this bill only requires majority vote.
Thank you. Any other witnesses in opposition? Before I bring it to the committee, authors, the committee is suggesting amendments. Are you taking those as authors' amendments?
Absolutely.
I figured that might be the case.
The committee had a little bit to do with drafting it in the first place.
Right. Thank you. Any member comments or questions? Ms. Garcia.
I want to thank the chairman for extensive phone calls and conversations he's entertained with me. Thank you for your time. And we discussed trying to have a less arbitrary discussion, and the opposition just mentioned testing, and I think going towards the idea of integrity. So before I ask the question of the chairman, if this bill at some point started to look and have penalties and the requirement of plugging some of these idle wells tied to integrity or these testings, would that then remove your opposition?
It depends on how the language is written, but if your question is, if penalties are still in the bill and there's still going to be a requirement that we have better testing.
Not just better testing, but that the testing is then tied to both fines and the possible requirement to plug some of these wells.
Yeah, I cannot speak to that at this point. It depends on how language is written.
To the chairman, and we've spoken a little bit, so I kind of have the answer here. You've spoken that you are in discussions with Dogger to try to move in that direction, both, and just to be clear, both on fines and plugging of these wells?
Right. Just so that people understand, the structure at this point is based on age of the well, and the changes are not changes that change that. So the structure has always been on the age of the well. However, it makes sense to me if there was a logistical way to make it more risk-based approach, whether that's integrity or another measure of risk, and we created a fine structure in that manner, I would be happy to present that. And last week, I asked Dogger to see if they could come up with a framework like that. We obviously do not have that ready today, and the proposal was only a couple days before from the industry. But if that were to get the industry to remove their opposition, we of course would want to try to do that. I'll just say, members, you would think that if wells were idle for this amount of time, that the number of idle wells would go down dramatically when the cost of oil is high. That is simply not the case. There has been between 19,000 and 22,000 idle wells in this state for the last 16 years. That has remained constant when the price of oil has fluctuated between $20 a barrel and over $100 a barrel. So when the price of oil, so if they are leaving these idle just because they want to use them later, you would think that that would change when the price of oil goes sky high. It does not change more than about 10%. So I submit to you that it would make us maybe suspicious of that supposition. It would make us go wonder, well, when it only costs the company $100 a year to leave the well idle, but it costs tens of thousands of dollars to close that well permanently, then maybe they're just avoiding cost. That is dysfunctional for the state when we have to pick up the tab if that company goes out of existence. That's why it's an orphan well. And that's how I was brought to this issue in the first place. I have an orphan well in my district. I actually have a lot. And looked at how little money the state has to deal with orphan wells. So we have two problems. There is not enough to deal with the amount of orphan wells that exist right now, and that our fee structure is so low that a company doesn't have much of a downside just to leave that well idle for 5 years, 10 years, 45 years. We've got thousands of wells that have been idle for between 20 and 45 years. If they're going to extract that oil, they might want to do it sometime within a 45-year time frame.
And just to wrap up, I'm not going to have opinion on that statement, but I will say that I think I appreciate where our author's going, and the idea, it's very logical to assess risk, and from risk move forward in making decisions that include fees, include whether or not we plug these wells or not. And so in that respect, I think with the commitment of the author that's where we're moving, I think that this is a very logical, smart way to proceed as we grow older as a state, our infrastructures grow older, and our public's opinions of where we should be as a state has also evolved along the way. So with that commitment, and as this discussion continues with Dogger, I'm going to be okay with the bill and look forward to seeing what it manifests itself along the way to have that logical piece where you guys are trying to move to now. Thank you.